Good morning, everyone. I'm going to wait a minute. We're admitting folks from the waiting room, and I just want to make sure everyone has a moment to fully connect here. Looks like, to my team, it looks like we have one left in the waiting room. Thank you. All right, I'm going to go ahead and get started. If we have more folks join us in the waiting room, we'll let those folks in. It looks like we have 47 participants on the line, so let's be a little patient with one another. But good morning, I'm Hearing Officer Nicole Kinsey with the Administrative Hearings Office of the State Water Resources Control Board. And this is a pre-hearing conference for the hearing on the pending petitions of Consolidated Irrigation District, Fresno Irrigation District, and Alta Irrigation District, and Semi-Tropic Improvement District of the Semi-Tropic Water Storage District, to revoke or revise the declaration of fully appropriated stream systems with respect to the Kings River system, on a potential revocation of water right licenses 11517 and 11521, and on a proposed cease and desist order against the Kings River Water Association and its member units. This pre-hearing conference is being held in accordance with the notice of public hearing and pre-hearing conference dated December 2nd, 2020, and that was from our office. This pre-hearing conference is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. So if you're not planning to participate today and you're on the Zoom call, if you wouldn't mind switching over to the YouTube channel, it's a live streaming, and that will allow you to view the proceedings without being on the Zoom call. Both the audio and video are being recorded, and we'll post files of this recording to the AHO FTP site as soon as possible, hopefully by tomorrow. The YouTube recording will also be available on the AHO YouTube webpage. So if there are folks that couldn't make it today, you will be able to, or they will be able to view this proceeding after the fact. If you are experiencing technical difficulties today trying to communicate with us, please send an email to the AHO at admin, ADMIN, HRG office, and that's all one, admin HRG office at waterboards with an s.ca.gov. And my staff working with me today will be monitoring the email inbox, and we'll try to make sure that you can get online if you're not able to do so. On that note, assisting me today are several staff of the Administrative Hearings Office. I have Nicole Mullen, Amy Blunk, Megan Nyes, Skylar Anderson, and Kyle Wooldridge joining me today to assist. Before we begin, I wanted to take a moment to give a little background because I realize there may be members of the public out there who are listening either on the Zoom call or on the YouTube channel who received notice of this pre-hearing conference and the hearing that's going to be held at some point in the future. We'll talk about that today, and are probably trying to understand what this proceeding is all about. So I wanted to just hold for a moment and give a little background. Semi-Tropic Water Storage District and 3 irrigation districts in the Kings River watershed, that's Consolidated Fresno and Alta irrigation districts, filed petitions with the State Water Board asking the board to consider whether to amend the board's declaration of fully appropriated stream systems. And this fully appropriated streams declaration currently states that the Kings River system is fully appropriated, and that therefore prevents the State Water Board from accepting any new applications to appropriate water from the system. The hearing on this matter is currently scheduled for April, but I think based on this conference, we're likely to postpone that somewhat. It'll be held at a later date. But that hearing will allow the parties to present evidence about whether the board's declaration should be revised to allow the board to accept new applications from semi-tropic or the irrigation districts to appropriate water from the Kings River system. Now, the hearing would not address whether those applications should be granted, but only whether water is available for the board to consider the merits of those applications. This proceeding is also not an adjudication of existing water rights on the system. If you divert water from the system or own land on the system that appears to be riparian to a part of the Kings River, or its tributaries, you should have received notice of this proceeding. The water code requires us to notify you if you fall within one of those categories, if the board holds a hearing on whether to amend its declaration of fully appropriated streams. So that's why you may have received that notice. But this hearing will not examine the validity of all of the individual water rights on the system. It's not a comprehensive adjudication, and it will also not change the priority of existing riparian rights on the system. In addition to consideration of the fully appropriated streams status of the Kings River system, there's a second portion to this proceeding that relates to the validity of specific water rights. And those water rights are documented in licenses 11517 and 11521 held by the Kings River Water Association. And it may also include pre-1914 appropriative water rights claimed by member units of the KRWA. Now, all this information about the proceeding is documented in more detail in the December 2nd, 2020 Notice of Public Hearing and the November 30th memorandum that was issued by my office, the Administrative Hearings Office. And both of these documents are available on the AHO webpage. If you have trouble finding that information, you may contact our office, you may email us, and we will send you a link or send you the documents. Additional documents associated with this proceeding, including the administrative record and all of the documents received by the AHO during the course of this proceeding, are available on the AHO's FTP site. And again, if you contact our office, we will send you information on how to access the FTP site and a password to access that site. Please also note that other than the requests that I described for basic information, the documents about the proceeding and how to access that information, there is a prohibition against ex parte communications. So all parties and interested persons are prohibited from communicating with members of the AHO hearing team unless all of the parties are invited to be present, as is the case today during this pre-hearing conference when we have a chance to discuss with one another. Or you may also contact the AHO in writing, in which all parties have been CC'd on that communication. That is also permitted. And if we need to, at that point, we can all gather together in a pre-hearing conference and discuss any of those issues. Now, that was a lot of talking. Thank you. I'd like to finally move to appearances, see who is on the phone. I see there's a number of us here. I'll start by identifying each of the entities that filed a pre-hearing conference statement. And as I do, if you're representing that entity, if you would please unmute your microphone and state your name, and then we'll move to the other parties. If there are other parties who wish to speak today and participate, I will ask you to identify yourselves. So let's go ahead and start with Semi-Tropic Water Storage District, please.
Good morning, Ms. Kinsey. Kevin O'Brien representing Semi-Tropic Water Storage District.
Thank you, Mr. O'Brien. Kings
morning,
River
Ms.
Water
Kinsey.
Association.
Good morning, Joe Hughes on behalf of Kings River Water Association.
Thank you. Good morning. Alta Irrigation District, Consolidated, and Fresno Irrigation Districts, which I believe we're calling the upper, is it the upper water districts?
The Upper River Districts. Good morning. This is Nick Jacobs representing those entities.
Thank you, Mr. Jacobs. Then let's move to the to Larry Lake Basin Water Storage District.
Good morning, Ms. Kinsey. Peter Keel for Tulare Lake Basin. Thank you.
Good morning, Mr. Keel. McMullen Area Groundwater Sustainability Agency.
Good morning, Ms. Kinsey. Robert Donlin, Ellison Schneider for McMullen Area Groundwater Sustainability Agency.
Good morning, Mr. Donlin. Laguna Irrigation District.
Officer Kinsey, Jennifer Spalletta for Laguna Irrigation District.
Good morning, Ms. Spalletta. And then California Department of Fish and Wildlife.
Good morning, Kathleen Miller, and I'm joined by Nancy Murray for the department.
Good morning to both of you. Thank you for all of you successfully making it onto the Zoom call. Let me see if I can move forward with in a orderly way here. I have received a contact, which this contact is posted on the FTP site if you would like to view the email. But I received a contact from Miss Macedo Schaefer, and I'm wondering if she is on the line and would care to identify herself if she wishes to participate in the conference today. And if you're joining on the YouTube channel, that is just fine. That is no problem. Now, anyone else who I have on the line who has not identified themselves, I will call out names based on the participants that I see in my column so we can move through this. And I apologize if I call your name more than once or you've already identified yourself. Ms. Aldridge.
Melanie Aldridge, counsel for Crescent Canal Company, a member of the KRWA.
Great. Thank you, Ms. Aldridge. And do you, I can understand you're on the line. I probably won't explicitly get to you, but to any of the participants, if you wish to speak, unmute your microphone, give me a heads up. We'll try to move through this orderly, but there are a lot of you, so bear with me. Looks like Aubrey Moritzen, and I apologize for names in advance.
Good morning. Thank you. No, that was absolutely correct. Aubrey Moritzen for Tulare Lake Basin Water Storage District.
Great. Bill Stretch. Mr. Stretch, if you're on the line, if you would just unmute yourself and identify whether you're here representing a party or representing yourself.
Yes, Bill Stretch. I'm the general manager of the Fresno Irrigation District.
Thank you, Mr. Stretch. Brett Stroud.
Good morning. I'm with Young Wooldridge. We're with Semi-Tropic Water Storage District.
Great, thank you. I have someone identified just as Carlson. Carlson, it looks like video off, maybe on the line if you wish to identify yourself. Otherwise, I'll move on. Oh, I lost Carlson. Chad Wegley. Mr. Wegley, do you care to identify yourself?
Can you hear me? Chad Wegley,
Yes, I can.
Alta Irrigation District.
Thank you very much.
You're welcome.
David Kahn.
David Kahn, representing Riverdale Irrigation District, a member of the Kings River Water Association.
Thank you very much, Mr. Kahn. Doug Jensen. Mr. Jensen, do you care to identify? Oh, I see your mute is off, but I don't hear you speaking. How about I'll put a hold on that and we'll come back to you because I see you're here. Drew K is the identification here.
Drew Kettleson. We are growers up in the Kings River Water District area for McClarty Farms and Angry Peacock Farms.
Great. Thank you, Mr. Kettleson. I will do my best. Chantel, is it Oulette, or Oulé? If you pronounce your name for me, I would appreciate that too.
Good morning, this is Chantal Ouellet, and I represent Tulare Lake Basin Water Storage District.
Great, thank you. Good morning.
Good morning.
Gary, if you are on the line.
Yes, I apologize. I didn't fill that out. Gary Serrato, Fresno Irrigation District.
Thank you very much. Good morning.
Good morning.
Jay Boswell.
Good morning, Jeff Boswell, General Counsel for the Fresno Irrigation District.
Good morning, Mr. Boswell. Jeffrey Meyer.
Good morning. I'm a consultant to Tulare Lake Basin Water Storage District.
Thank you. Good morning. Ms. Spalletta, I already heard from. Looks like Jay Gianquinto.
Yes, Jason Gianquinto, General Manager, Semi-Tropic Water Storage District. Thank you.
Thank you. And Mr. Hughes, I already have you. Jay Westra.
Hi, good morning. Jacob Westra, Tulare Lake Basin, Water Storage District.
Good morning. Lauren Lane.
Yes, good morning. My colleague Doug Jensen and I serve as general counsel to Alta Irrigation District, Consolidated Irrigation District, and 2 other Kings River member units, Kings River Water District and Tranquility Irrigation District.
Oh,
I'll
good.
speak for Doug too.
Thank you. Good. Well, check Doug off the list. Thank you. Lita Spencer.
Hi, from the Westchester Investment Group Management.
Thank you very much. Good morning. Mark Coelho.
Good morning, Mark Coelho, also from Westchester Group Investment Management.
Thank you. Good morning. Melanie Aldridge. I didn't call it. I have not. You're not on my list yet, I don't think. Melanie Aldridge.
Yeah, you called me first, actually.
I'm sorry.
With Crescent
Crescent
Canal.
Canal. There you are. Thank you.
Thank you.
The ordering of things keeps moving here. Michael Swanson. Mr. Swanson, are you on the line? You'll have to unmute yourself. I will come back to you, Mr. Swanson. P. Desitoff.
Yes, this is Phil Desitoff, General Manager, Consolidated Irrigation District.
Thank you. Good morning.
Good morning.
Mr. Keel, we have already spoken to. Mr. Donlin, we've spoken to. Russell McLaughlin.
Good morning, Russ McLaughlin at Terra Nova Ranch.
Good morning, Mr. McLaughlin. Sam Bivens. Mr. Bivens, I believe, well, you can tell me who you're with. Good morning.
Sam Bivens, good morning. Sam Bivens, Downey Brand for Semi-Tropical.
And I apologize, Mr. Bivens. I think I had your name spelled incorrectly on our service list, but we fixed that.
It happens all the time.
I'm sure it does. Jeff Wyrick. Mr. Wyrick. Or Geoff, is it Geoff Wyrick? I don't see a microphone for you, so you may not be connected to the audio. I'll move on and we'll come back to you. I also have a phone number which shows up as 818-952-2487. Would that person care to identify themselves? Moving back on those I missed, I believe it was Mr. Swanson. Mr. Swanson, are you on the line with audio? Mr. Swanson, Mr. Wyrick, and then a few phone numbers. Is there anyone else on the line who I have not yet identified? Oh, I have a few more joining in. Scott Sills. Mr. Sills, would you please identify yourself? All right, we'll pause there too. Is there anyone else who has not had a chance to say good morning and identify themselves?
Yes, this is Steve Torgiani, Counsel for Semi-Tropic Water Storage District.
Great, thank you, Mr. Torgiani. Anyone else?
Yes, good morning. Steve Haugen, Water Master for Kings River Water Association.
Good morning, thank you. Others? Any others? Did we make it through 41? Good morning. We made that. We checked our tech. If any of you are having technical difficulties, we're not able to join by audio, please go ahead and email our staff. They will try to alert me and we'll see if we can work through that. Again, it was, let me make sure I get the email address right. Admin, HRG office at waterboards.ca.gov. So as we proceed, please keep your microphones muted except when you're speaking. That way we can minimize the background noise, especially with 42 of us on here. But if possible, please enable your camera, especially when you're speaking, so we can all see each other. That's helpful, I think. So let's get started on the substance. The purpose of this pre-hearing conference is to address procedural issues related to the conduct of the hearing and the scope of the hearing. I received the joint pre-hearing conference statement from Semi-Tropic KRWA and Alta Consolidated and Fresno Irrigation Districts. Thank you very much for that joint statement. And I also received the pre-hearing conference statements from Laguna Irrigation District, McMullen Area GSA, Tulare Lake Basin Water Storage District, and CDFW. Thank you for all of those. And I have read them carefully, so keep that in mind today. I have read all the statements. I'd like to move through the discussion today, hopefully in an organized way. There's a lot of issues to cover, but this is generally how I'd like to proceed. And I apologize, it is not in the order of 1, 2, 3, 4, 5, 6, 7, 8 as the issues were laid out. And I realize some of those overlap, but let's start. I'd like to start with the phases of the hearing, the procedures to apply, particularly in phase 1A. I think today we really want to focus on phase 1A because it sounds like we have a fair consensus that that's how we should proceed in phases. And then also the outcome of each phase, whether or not there would be a board approved order, we can at least touch on that topic. I think these generally map to issues 3, 5, 7, and 8 that were identified in the hearing notice and pre-hearing conference notice, and then also my letter of January 13th. So that is one. Second, let's address the timing of the hearing, including when we should start the first phase and then associated pre-hearing deadlines. And I think related to that timing, that's when we should talk about timing for motions to dismiss or dispositive motions, however you want to phrase those. Those are raised by the Kings River entities. Number 3, we'll address the additions to the hearing issues identified in the notice of public hearing. That was the topic number 1 in the issues to be addressed today. And then last, we'll get to the other miscellaneous topics. I know there's a handful of those. So I'm going to invite your comments on each of these issues. I'll move through the parties that filed pre-hearing conference statements, but if others want to speak, I will, please just unmute your mic and let me know. Keep in mind that I have read those pre-hearing conference statements, so this is an opportunity to respond to the other parties or add to any information you've already provided in your statements. There's no need to repeat the information. I've read those. So let's get started with the first phase. There seemed to be, so based on the pre-hearing conference statements, it seemed to me that there was no objection to conducting the hearing in the general phases that I laid out in my January 13th, 2021 letter. So with that approach, phase 1A of the hearing would address the threshold questions of whether there's evidence tending to show that licenses 11517 and 11521 should be revoked, or a violation of a requirement described in Water Code Section 1831, subdivision D, is occurring or threatening to occur. In phase 1A, the AHO would consider the evidence and determine whether the evidence supports giving notice pursuant to Water Code Sections 1675.1 and 1834, with a statement of facts and information on which the board's consideration of a proposed revocation of the licenses and a proposed cease and desist order would be based. So my first question to you is, what hearing procedures should apply to phase 1A? I noticed that everyone seemed to agree that there should be live presentation of evidence, so I appreciate that. We can do that. That's fine. My caveat there is that we don't want to be hearing the same evidence again in phase 1B. So we probably want to talk through and think about those issues and how to move forward in a way that doesn't overlap. keep in mind that I think the amount of time that I'll allow for witnesses during phase 1A is going to directly correlate to the amount of time you would be allowed in phase 1B if we get to a phase 1B hearing, right? Because we're not going to hear it twice. Now, when I wrote my letter of January 13th, I had envisioned at that time that phase 1A might essentially consist of Semi-Tropic putting on its case related to the matters raised in its complaint, or at least as much of its case as it believed necessary to demonstrate basically a prima facie case or a probable cause showing for purposes of issuing a statement of facts and information. Now, I gather from the pre-hearing conference statements that the Kings River entities probably also want to put on evidence, and I actually thought, Mr. Keel, your statement was helpful in this respect, that there may be other information about the licenses and about the, for lack of a better word, the plumbing in the system that might be really helpful for me to understand. So we can do that. We can allow parties on both sides of this to put on evidence, but I also want to think about the timing of the phase 1A hearing, right? If we keep the presentation of evidence by the Kings River entities more to phase 1B, that's going to allow you more time to prepare for the hearing. I know you've asked for 3 months, and that would naturally occur if we have a break between phase 1A and phase 1B, and if most of the presentation of evidence is in phase 1B on the merits, then you'll have more time to put that together. So all of those things I'm thinking over. I also noted the Kings River parties mentioned the possibility of a stipulation about the use of prior testimony and evidence, and that makes a lot of sense to me if the parties can work that out. So I would certainly encourage you to talk about that. So I'm going to pause here because I want to hear from you, but those are my thoughts so far. I'll start with Semi-Tropic, and on most of these, I'll start with Semi-Tropic, hearing from Semi-Tropic, and then we'll move to KRWA, and then the upper water districts, and we'll go forward from there. So, Mr. O'Brien, would you like to comment?
Thank you. First of all, we, as you know from the joint statement, we support your proposal for a phase 1A. Our understanding was the same as yours, that it would essentially be an opportunity to put on a prima facie case on the issues raised in our complaint. I think the challenge we have here is that if we're not careful, phase 1A could mushroom into essentially a full-blown phase 1A and 1B, because I think it's pretty clear that the issues are interrelated, and to the extent that the Kings River interests want to present their own testimony, which they're certainly entitled to do, if we don't put some sideboards around that, we're essentially going to have the entire case relating to the complaint in this first phase of the hearing. And in particular, I think some of the, what I'll call the second level issues relating to Sigma demands and some of the issues raised by Mr. Keel, personally, I think should be saved for a later phase of the hearing. And I think your initial approach of trying to focus very narrowly on the complaint issues was the right one. So generally, we support that approach. In terms of the hearing itself, I think we've proposed an hour for our direct testimony of each of our witnesses and an hour of cross-examination for each of the witnesses on the other side. We're flexible on those timeframes. We understand you'll have multiple parties to deal with, but I think in particular with respect to our case in chief, there will be a lot of technical and historical data to put into the record, and we want to make sure you have a chance to listen to the witnesses and ask questions. So I think an hour per witness is probably reasonable. So I'll stop there. I don't know if there's any questions about that.
No, thank you. We may get back to, on the issue of timing for witnesses, I think we'll circle back to that later in this conference. But no, thank you for your comments, Mr. O'Brien. And let's move to Mr. Hughes.
Thank you.
I think the concern, one of the concerns that we have with just focusing on the complaint and the presentation of evidence from Semi-Tropic focusing on the complaint in phase 1A is that the Kings River system is complex. As Mr. Keel pointed out in his statement, there are a lot of other issues that bear on an understanding of how the whole system works. And so the concern is if you just focus on some selected issues out of the complaint, you miss the totality and the entirety of the Kings River system. And so if this is going to be the launching off point, I think our position is that Kings River Water Association and the other member units who are participating need to have the opportunity to present their story, if you will. This is the KRWA, this is the Kings River, this is how it works since 1927. To understand all of that, having tried one case now with respect to the Kings River Water Association, it took a little bit of time, but it was worth the investment. In that case, the judge appreciated understanding, oh, this is how the whole system works. Here's who's who, here's how this thing is supposed to go. I think that investment at the ground floor will pay a dividend in understanding later. So again, just focusing on the complaint, I think that's a little bit too myopic. And I think, again, as we get started here, the Kings River Water Association should be given the opportunity to present, here's the system, here's everything that goes into the watershed. And I think Mr. O'Brien touched on the Sigma issue. That's certainly an additional issue that we identified, because if there is to be quote unquote probable cause or evidence tending to show a violation, it has to be done within the context of the Kings River watershed. Again, you can't take it out and just look at it in a vacuum. You have to understand what's happening in the watershed. If there's going to be some finding of evidence, I view this almost like a preliminary hearing. And so I think in both sides, prosecution, defense have to have the opportunity to put on a basic case of what the situation is and how the system is supposed to work. So again, in short, on the particular issue of focusing on the complaint, I think that the Kings River Water Association and then the other units who are participating should be given their opportunity to explain and provide the background and the foundation for the Kings River Water Association and the Kings River.
So maybe if I can just ask, I think based on that, it would be to some extent, and correct me if I'm misstating this, but to some extent front loading some of the issues into phase 1A with the expectation that that information will be relevant if we get to a phase 1B, and then also with respect to phase 2 on the FAS declaration.
I think that's right. And I think as you touched on, it would be incumbent upon the parties to work on identifying stipulated facts and whatnot from the first phase that would be used in the second phase. But I see this presentation, and I'm taking to heart Mr. O'Brien's comment that it can balloon, phase 1A can, and subsume phase 1B, but at the same time, if we're not given the opportunity to put on the appropriate case in phase 1A, phase 1B may already be done because the facts that we have not been able to controvert have been established. So again, maybe a long way of saying, and I think you touched on it earlier, I think the parties working together after 1A can identify the testimony that was already provided so that we don't have a duplication of effort in 1B.
Okay, that makes sense to me. With the one clarification, I do want to clarify that my understanding of phase 1A would be, to the extent it's sort of a probable cause determination, it wouldn't be, the factual findings wouldn't be binding. The evidence may be in the record, but these facts would be examined under a different standard in phase 1B if and when we were to get there than they would be in phase 1A for a probable cause or a prima facie case determination. So I just wanted to clarify.
Understood.
Understanding. Yeah. Thank you. Mr. Jacobs.
Thank you. I want to take a step back. My clients and KRWA as well, I know, had significant concerns about the original notice in this matter that suggested that the allegations in the semi-tropic complaint would be used as the statement of facts in this matter. And we sent you a letter. I think that the phasing process that you have identified addresses that, and we very much appreciate that. So I wanted get that out there. One of the things that I'd like to talk about today is the review process between 1A, 1B, and 2. I want to confirm that we have an opportunity to seek review by the full board and judicial review as appropriate. And I wanted to talk about that and figure out the rules on that today. In our pre-hearing conference statement, we have requested the opportunity to file essentially a dispositive motion in phase 1A, something that you could take up there. This is a little bit of a different process. Actually, I think this is a unique process as far as a complaint. This is being teed up as semi-tropic versus the KRWA, whereas the normal process, it would be the State Water Board would have issued a draft cease and desist order. It would be the enforcement team, prosecutor, and then we would have a hearing officer. So this is a little bit of a different process. I think that it is important, therefore, that we establish the rules for the review. And I also think part of that is this dispositive motion, because I think there are some serious standing issues with the semi-tropic complaint at the outset. And I actually agree with Mr. O'Brien on the timing, the length of the presentations. I think we might have been a little too hopeful that this could be, more of an oral argument type. It's not. He's right. I think an hour for witnesses, an hour for cross-examination is appropriate. All right, I'm going to stop there.
Thank you, Mr. Jacobs. I think some of those issues, I do want to move back to the dispositive motions. I appreciate that was a significant matter that was raised in the pre-hearing conference statement, and we will get to talking about that, and I do think that's important. I'm going to move through, I think, continuing to focus on phase 1A and what the presentation of evidence might look like in phase 1A. So I will move to Mr. Keel, please.
Thank you very much. Tulare Lake Basin Water Storage District supports Mr. Hughes' comments and recommendations regarding the necessity for a comprehensive phase 1A. We also believe that providing the time here, front-loading some of this discussion, will lay a foundation and should streamline latter phases of the hearing. We support Mr. Jacobs' comments about the ability to submit a briefing at the conclusion of each phase, specifically regarding dispositive motions potentially. I'd say we differ though in the amount of time for evidence. I do not believe that 1 hour for presentation of case in chief would be adequate for my client. And just one reason, kind of explaining why we think it's more involved than that, is that at least the junior license that is pertinent to the Tulare Lake bed includes sources other than Kings River water. This hasn't been really analyzed or discussed in semi-tropics papers. I think it would take considerable amount of time just kind of describing what those sources are and how water is managed in this area. I think it has a direct bearing on allegations of forfeiture, potential revocation, as well as water availability. Thank you.
May I clarify one point?
Absolutely.
I am not requesting an hour total. I'm requesting an hour, up to an hour per witness. I believe that's what Mr. O'Brien was requesting as well.
That is what I heard. So thank you.
Clarifying.
And Mr. Keel, I think in your pre-hearing conference statement, did you ask for, was it 4 hours total or 4 hours? What is the number that you were asking for?
We've requested 4 hours total for Tulare Lake Basin's witnesses. So I do anticipate that our 2 witnesses may require more than 1 hour each, possibly up to 2 each.
Understood.
Thank you.
And that, just to clarify for all, especially if there are some on the line who haven't participated in a water board hearing, these presentations of testimony would be a summary of the written testimony that would be submitted in advance. I realize with complex cases, it may take some time to summarize testimony, but just clarifying for all of us, this is a summary of the written testimony, which I would certainly read in advance of the hearing. Thank you, Mr. Keel. Mr. Donlin, do you have anything to add?
Thank you, Ms. Kenzie. I have nothing to add. We support the concerns that Mr. Hughes raised in terms of making sure that there's an appropriate level of hearing on background and contextual issues in phase 1A, and not narrowing of the hearing issues for that particular phase. As to the timing of witnesses, we defer to the other parties, the principal parties on that.
Thank you. Ms. Spalletta, do you care to add today?
Just briefly, we also support the phasing. I think that the way that it's been discussed this morning, the phase 1A and 1B makes a lot of sense. I also I think we all know that this is kind of new territory for the AHO, and I do think it's very important that we're clear on burdens of proof and the factual findings that will be made and how they can be used in subsequent phases or not used in subsequent phases. And as Mr. Jacobs described, what the review process is for the board and potentially judicial review at each phase. I just think spelling that all out is going to be helpful to the process, and this is a bit precedential, so helpful for potentially for future processes. At this point, I don't know that I will be calling any additional witnesses. I'll reserve that right to when I file a notice of intent, but I will want the opportunity to cross-examine witnesses. And so I anticipate that cross-examination would be potentially between 5 and 15 minutes per witness. Obviously, if there's a technical expert that has a significant report, that might be a little bit longer, but I think that should be built into the timing. Please. That's it.
Thank you. And CDFW, Ms. Miller or Ms. Murray?
We, as laid out in our letter, support the phasing as proposed in your January 13th letter. At this time, CDFW does not anticipate participating in phase 1A or 1B. So we will leave that to the other parties.
Thank you. All right. So I think, thank you for that. I think my next topic was going to be the timing for testimony and cross-examination, which we have touched on in this process, although I'll give a moment if any of you care to circle back to it. But thank you for your comments on the amount of time. I think I'm going to take this under consideration and thinking about it, all of these features go together. What is the scope of phase 1A in terms of how much evidence is going to be put on, how much detail we need to go into, and that of course will affect the time limits on witnesses. And then also the timing for setting the beginning of phase 1A, which we will get to that in a moment. On cross, what I'm thinking at this point on cross-examination, I think I'm not going to set explicit limits for this phase 1A, at least so far. I think all of you who have spoken today have participated in waterborne hearings. You know how it works. You know how to move things along. And I know these issues may be complex and there may be need for flexibility. So I think I won't set an explicit limit in advance. We will, as long as we're being productive on cross, we'll move forward. So we'll see how that goes for phase 1A. But I will think about limits for that summary of direct testimony, because I think that will be helpful. Are there any other comments on time to present evidence for phase 1A? Witnesses, I should say, witness summaries. Does anyone else care to comment? Any of the other parties who haven't had a chance to speak on the scope of phase 1A, the phasing, or the time to present witnesses? You may unmute your mic if you would like to speak. All right, I'll move on. And this gets to an issue that also has already been raised about proposed orders after each phase. the question of whether or not the AHO would issue a proposed order for the board, which then would be subject to petitions for reconsideration, the standard review for board orders, and then also potentially judicial review if it's ripe. Now, the outcome of phase 1A, and as we're talking about it, what I'm thinking is this may merit some additional briefing from you in advance so we can help lay out the scope of phase 1A, exactly what facts would be binding. It may be appropriate to talk about how a stipulation would work, and then also burdens of proof. So I appreciate that this is a very important issue, and I agree with the comments that have made that we want to lay that out in advance so that everyone understands what the outcome would be from each phase. But what I envision the outcome of phase 1A would either be dismissal of the hearing issues related to revocation and the cease and desist order, or it's going to be issuance of a revised notice with a statement of facts and information, and that would then start the process towards a phase 1B hearing. Now, normally, if, for example, the enforcement section issues a draft cease and desist order or a complaint of some kind, that's not subject to adoption by the board or judicial review. So that's not what I'm envisioning as an outcome for phase 1A. Now, there's the dispositive motions; those are different, and we'll get to those. I recognize that that's potentially different if that went to a board order. On whether or not a board order should come out of phase 1B, that I'm not sure that's an issue we need to address right now, although I'm going to ask to hear from all of you about whether we need to address that right now. It seems like we could address that before we go into phase 1B, if there is a phase 1B, to decide whether or not there would be an order that goes to the board for adoption at that point, or whether there's just one final order after both phases 1 and 2. But it's far enough down the road that at this point, I think we should be focused on phase 1A and get to that issue later, because the issue may become moot if there is no phase 1B. So I'm going to go down the list. I would appreciate if you have any comments on that issue, on the outcome of phase 1A, and then whether we can defer the issue of whether there should be a final proposed order out of phase 1B. I'd like to hear from you now. We'll start with Mr. O'Brien.
Yes, I think we addressed this in our joint statement, Ms. Kinsey. We strongly feel that there should not be judicially reviewable orders out of any of these interim phases. I think carving this proceeding up in that way would be extremely disruptive. Frankly, I've never seen the board do it. I think about the lengthy and complex hearings the board has had on Bay Delta water quality, where there were multiple phases. The board has never issued judicially reviewable interim or interlocutory orders during that phasing. So our very strongly held view is that we should get to the end of this initial hearing process, and then there should be an order issued. And I think your earlier comment that none of the findings made in earlier phases would be binding on the hearing officer or the board. That's typically how, as you know, courts handle these things. There's the ability to revisit findings in later phases of a trial, and that often happens. So I think maintaining maximum flexibility for the hearing officer makes sense. And we simply don't think there's any legal authority for the notion of, for example, making phase 1A judicially reviewable. It's not a final administrative order.
Thank you. Mr. Hughes.
With respect to phase 1A, I think Ms. Kinsey, you touched on something that's important here, which is if this was a quote unquote normal proceeding, there would be an enforcement team that would write up some sort of statement of facts, and then off to the races we would go, and the board would not review that. Totally understand that, and that would be in the normal set of circumstances. But as I just said, this is not normal. And so what you're doing, and we agree with the process, because we think all in all, it makes for an efficient way to make our way through this. You as the hearing officer will be hearing evidence to determine whether there should be a statement of facts, and you'll be preparing that and sending out the notice. And so you'll be sitting in some respects as what the enforcement team would be doing. And so we think in terms of, from a process standpoint, it would be appropriate, because this is a new way of doing it, it would be appropriate to allow us for at least administrative review to the board following phase 1A, because again, you're absolutely right. The enforcement team wouldn't run it by the board, but that's not what we're doing here. And you're in the unique position now of hearing this quote unquote preliminary hearing and then determining whether there is enough evidence to proceed to phase 1B. And so all we're asking for is at least the opportunity for administrative review at the end of phase 1A because of the uniqueness of the situation. That's as to the phase 1A. As to phase 1B, I just simply don't see how there can be a revocation of a license without full administrative and judicial review. That's what the complaint seeks. And I understand as a matter of procedure, we're trying to wrestle this to the ground as best we can. And so we've combined the fully appropriated stream petition along with the complaint. But if there had been no FAS petition, there would only be the complaint. And so the complaint should stand alone for purposes of due process. And so if at the end of phase 1B, there is a finding of a cease and desist order or a finding of revocation, then I think we absolutely are entitled to full administrative review and judicial review of that. Anything less than that, I think short circuits due process.
Well, and to clarify, just to make sure I'm understanding you, it's a question of timing. I think I didn't mean to imply that at the end of, one option is for there to be a proposed order to the board after phase 1B, and the other option is all of the issues, including the potential revocation, the cease and desist order, and the FAS declaration issues would go to the board in one package after phase 2. I think there's no doubt what the AHO does is issue a proposed order for the board. So either way, there would be a board review. The question is timing. Does it occur between phase 1B and phase 2, or does it occur after phase 2? So I just want to clarify that, and if you care to comment on that.
Sure, thank you. And maybe I pushed all of that together. In my mind, there absolutely has to be that review after phase 1 before you launch into phase 2.
Mm-hmm. Thank you. Anything else, Mr. Hughes? I see you muted yourself, so I'll take that as a no. Mr. Jacobs.
I agree with Mr. Hughes entirely. This is not the phasing of a single matter. We've done that for sake of efficiency, but these are two separate matters, right? There's a complaint and that process, and then there is the FAS process. It's not like the Bay Delta proceedings. The legal authority for the administrative and judicial review and the issuance of an order between the two phases is Water Code Section 1114, which I'm sure the hearing officer is familiar with. And I would also just say as a practical matter that there are significant issues involved in the complaint that if they were decided one way in this hearing and another way on judicial review, would entirely undercut the FAS proceedings if those were to go forward prior to full judicial review. So I think there are some practical issues, there are some efficiency issues, and then there is just the plain legal authority to do the review between the phases of these two separate matters.
Thank you, Mr. Jacobs. Mr. Keel.
Thank you. I support Mr. Hughes and Jacobs' comments regarding phase 1A findings. The suggested clarification that findings would not be binding on subsequent phases doesn't give a lot of comfort when I fear as a practical matter, factual evidence and findings regarding potential non-use and potential forfeiture absolutely will be precedential. And so I guess we reserve our right to submit briefing and insist that an order does go to the water board at the conclusion of phase 1A. It's a little premature for me to comment more specifically at this time though.
And I'm just going to jump as a group. Are there any others on the line who care to comment on this issue at this time? Ms. Valletta, I see a hand raised. Thank you.
I would just want to agree with Mr. Jacobs and Mr. Hughes. I do think that the issue of forfeiture should be a separate board order that is appealable before you get to the issue of the fully appropriated stream. A fully appropriated stream hearing is going to turn on multiple issues, only one of which potentially is the forfeiture. But the forfeiture decision could be foundational fact for the FAS hearing. And if that was overturned by a court or sent back to the state board for reevaluation, it would upset everything that was done in the FAS hearing, which doesn't make any sense. So they should be completely separate orders and separately appealable.
Thank you.
Ms.
Anyone
Kinsey, may I make one quick comment there?
Yeah, absolutely, Mr. O'Brien.
I just want to make it clear that Semi-Tropic's position is that regardless of what happens with the complaint, there is water available for appropriation on the Kings River. And that so the two, although I agree certainly the issues in the complaint are related to the FAS issues, I don't think they're determinative of the FAS issues.
Understood. Is there anyone else on this issue? Great. I'm going to move on. Let's see what we have here. The timing. Let's talk about timing of when phase 1A would start. So I believe, Mr. O'Brien, you indicated in your pre-hearing conference statement that Semi-Tropic is willing to agree to a 30-day extension. That would be to May 17th. And the Kings River parties as a group, I believe, are asking for 90 days. You know, I appreciate that 90 days is not a particularly long period of time. I read the statements. I understand the scheduling conflicts in place for, excuse me, my Zoom was cutting in and out. I see movement, so I know I'm live, I think. I read the statements. I understand the scheduling conflicts. I understand there's a trial scheduled for April. It sounds like you're quite busy. I appreciate that. So I do want to think about what makes sense. Our discussion of what phase 1A would entail has been quite helpful because that helps me think about how much time might be reasonable for folks to prepare. On the issue of the records, I know that was raised. The records room has been closed. COVID is happening. We're all dealing with that. Just as a note, my understanding, if the records room staff are not already back in the office, they should be back in the office by February 1st and working on those requests. But I was wondering if, Mr. Keel, I believe it's your PRA request. I was wondering if you'd be willing to talk about, to the extent you're comfortable, what those records are, because I'm wondering if some of those records we may want in the administrative record no matter what, and I can actually ask some of my staff to work with the records room to get those scanned and up on our FTP site. So I was wondering if we can just specifically talk about those records and what might be needed and if my office can be helpful in any way. Mr. Keel.
I appreciate that. Since submitting the pre-hearing conference statement, we did get some historic documents from KRWA. So our need for some of the older historic documents is no longer required. Great. We are, honestly, I'm not sure what might be missing from previous requests.
Yes.
Or recent correspondence or files that may be located on board staff desks. And you did locate a change petition that was included in the FTP site, which was not included in prior public record productions for the actual water right files.
Okay.
So it's in part, it's an inquiry to confirm that there is no other information.
Understood. Well, let's go ahead and jump in on this issue of timing. I mean, I've read your statements, but I think it'd be helpful to have a discussion again. It's a question of a 30-day extension or a 90-day extension. It's not a big difference, but if there are other issues that you'd like to comment on in terms of that timing or conflicts, the summertime is sort of a difficult time to hold a hearing. I would have preferred to do it sooner, but let's just talk through some of those issues. We'll start with Mr. O'Brien.
I guess the only thing I would underscore, Ms. Kinsey, is that this matter has been pending now for almost 4 years. And I think all the parties have known these issues were live and have had plenty of time to prepare for the initial part of this hearing process. So, to be honest, I don't have a huge problem with 90 days, but I think we would be very concerned about kicking it out more than that. Semi-Tropic has put a lot of resources into developing its project, and it's prepared to move forward with that project. And we believe further delay would be to our prejudice.
Thank you. Mr. Hughes.
We gave a fair amount of thought to the 90 days. If we were asking for something like 6 months, I think that Mr. O'Brien's point would be well taken. But given that we've now identified what the issues and the scope of the phases will be, I think we can now set about getting to work. And that's sort of the overall comment. And as you saw in my statement, or our statement, I've got this practical issue and also a sanity issue of trying to combine too much stuff into April and May. And if this is a hard start date, and I didn't really get to touch on this, if this is a hard start date, my April date, as I pointed out in the statement, it's a bench trial with opposing counsel perhaps coming in hot from a jury trial. And so it may have to slide. And so I'm concerned about getting pinched if we have the May date or even a later date. So that's why we were judicious in trying to propose something that addressed the timeliness issue, but then also gave us an opportunity to fully and adequately prepare, which is how we came up with the 90 days.
Thank you. Mr. Jacobs, do you have anything you'd like to add?
I will just say that these matters have been pending a while. However, we got our notice in December, so things are now ramping up quickly, and I don't think 90 days is a long time to ask. And I think it will be put to good use to prepare good presentations for phase 1A.
Mr. Keel, would you like to comment?
Nothing further. Thank you.
Thank you. I was just looking back, I was flipping through and looking at the proposed deadlines. I'll take a look at these deadlines. I mean, part of this too is if we are going to have a little more time, I may set slightly forward the deadlines for exhibits. Although June 1st isn't bad, that's the proposal. I'll think about it. I just want to make sure also on my end that I'm not putting myself in a situation where I have thousands of pages to read in 2 weeks, but this may be okay. So that's what I was just flipping through on that. Thank you for your comments. Is there anyone else who cares to comment on the timing of the start of phase 1A? All right, hearing none. Let's move to dispositive motions and closing briefs. To me, these two issues kind of go together. There's a question of whether to allow and then when to allow motions to dismiss, I'll call them, or dispositive motions. I do think it makes sense to allow these motions when appropriate. I mean, there are issues that I think are appropriate to be aired and are important with an appropriate page limit. I think for closing briefs, a page limit was proposed, and I think we can work out an appropriate page limit at the right time for dispositive motions. To me, the timing seems correct to do those dispositive motions after phase 1A, because that's the point at which we will be looking at whether or not we're actually going to a phase 1B. And it also might be inappropriate to combine those with, I don't know, you can tell me whether they should be combined with closing briefs or whether those should be separate briefings. But it seems more efficient to me to do those after phase 1A, although if it's something you'd like to do in these, I think we still have 6, if we were to put the hearing at starting in July, we have 6 months, we could get this briefing done. That may be efficient. So I just wanted to get your comments on the timing of those, but I am inclined to allow them. I do think they're important issues. It's just a question of when. So we'll start with Mr. O'Brien.
I tend to agree, Ms. Kanzi, that at the following of the Phase 1A evidentiary presentations, you'd then have a record that would inform your ruling on these motions. Without belaboring it, I will say that we don't think the standing motion has any merit whatsoever. I'm not sure whatever motions the other parties have in mind, but it seems to me that having them after you have some context and some record makes sense.
Thank you. Mr. Hughes.
I think the motion to dismiss, as with civil proceedings, should be taken up first, because if that is a meritorious motion, then we should all go home, so to speak, with respect to the complaint. And so I think we need to dispose of that. And if we need to move that up, so we're not hearing it on the day of trial, so to speak, I think we're open to doing that. But the idea of hearing it early on is so that we can avoid the time and expense of preparation and conducting a Phase 1 hearing if there's no standing. And, you know, I understand Mr. O'Brien's commentary, but their project is half cooked. It's not ready for prime time. And that's why we would like the opportunity to file the motion to dismiss, because they shouldn't be proceeding where they are right now. And so we'd like that opportunity, and really it's designed to avoid the time and expense of preparing for and going through the hearing process for a complainant who's got no interest on the Kings River.
And so just to verify, you see these motions as truly motion to dismiss. I mean, without evidence that's formally been admitted into the record that these could proceed, because I don't think I want to split them up. We have motion to dismiss and then motions essentially for summary judgment later. I think we should just do them together. So I just wanted to clarify that that's what you view these motions to be, something that could be done upfront without, I mean, we have the basic facts that we could take judicial or administrative notice of. But other than that, these are motions you see going forward without evidence in the record.
Yeah, and that's how I viewed it, as a true motion to dismiss when a party lacks standing.
Mr. Jacobs, do you have additional comments?
Sure. So I'm not quite sure how to understand the difference between a closing brief that argues to dismiss and not proceed to Phase 1B versus a dispositive motion at the end of Phase 1A. Those seem to be the same thing to me.
Mm-hmm.
As with Mr. Hughes, our inclination was to file this up front on standing. So, I don't think it is a really an evidentiary analysis. It is a very legal analysis. I mean, Semi-Tropic doesn't claim a Kings River water right. They don't have an application that's been accepted by the board. How can there be a clash of rights on their forfeiture claim? Under Water Code 1834, there has to be an actual permit violation or a threatened permit violation. Their sole allegation is that KRWA diverts water up the James Bypass North Kings in flood conditions. Well, we can show you the Army Corps of Engineers manual. We can have the Army Corps explain to you that that's a flood operation that they operate. So there are very threshold procedural standing issues that, frankly, we think should be heard sooner and warrant dismissal.
So I think you just confused me, because I think you just said we can have the Army Corps of Engineers explain the manual. And you also just, I believe, if I understood correctly, your sense that closing briefs and a motion to dismiss after Phase 1A would essentially be the same thing, which I tend to agree with. Can you clarify for me, but you're also asking to move these motions up front. Can you clarify, are you asking to hear these motions before Phase 1A has occurred and before you'd have an opportunity to put, you know, an Army Corps witness on the stand? I just want
to yes. I think we could submit a simple declaration with the Army Corps manual and an explanation of how the flood operations work that would show it's not KRWA diverting water outside its place of use on its permit, for instance. But I do feel like at the end of, if we go through Phase 1A, at the end of Phase 1A, there will be closing briefs. There will be an argument made in those briefs to dismiss and not go to 1B, right? So to me, that's sort of the same thing as a dispositive motion at the end of 1A.
Understood. Mr. Keel. Do you have anything to add?
I'm not sure I have anything to comment on motions generally versus dispositive, but I do like to clarify we intend to submit briefing on a number of things, including burdens of proof, clash of rights, and related issues.
Okay. Thank you. Is there anyone else who wants to comment on this issue, or Mr. O'Brien? I don't know if you wanted to respond in any way.
I would encourage the hearing officer, Ms. Kinsey, to do what a federal judge would do in a situation like this, and that's evaluate the pleadings that are in front of you. We could spend a lot of time and a lot of effort on a pre-hearing briefing process, and now we're talking about declarations, so there will be counter declarations. The idea that Semi-Tropic doesn't have standing to bring the complaint simply because it hasn't, for example, completed its EIR that's not what the law requires. We have filed a water right application on the Kings River. It has not been accepted for filing only because the FAS determination is in place, but there's no legal authority that I've seen in any papers presented that suggests that there's a significant standing issue here. And so I'm just very concerned that we're all going to get diverted off into this standing issue and frankly waste a lot of time and resources. Obviously, it's your decision whether you want to go through that process, but I think it's a mistake.
Thank you. Is there anyone else who wants to comment on this? I'd like to then move on to what I've titled in my notes as the scope of the hearing. I know several parties, I want to acknowledge several parties raised issues in response to my request about whether there are any additional issues that should be identified in the hearing issues. I'd like to focus just on phase 1A because that's where we are. I think some of the scope we'll understand better, and I will understand better after phase 1A. So I'd like to defer on phases 1B or phase 2. And just so you know, what I envision is after phase 1A, if we're going to a phase 1B, there will be a hearing notice or amended hearing notice, we may call it, supplemental hearing notice that would identify the issues to be heard in phase 1B. And the same would be true for phase 2 when we proceed there, so that we will move forward incrementally and we'll have a chance to make sure that our focus is appropriate as we step through each of these phases. I did want to address, though, the issue raised by Mr. Keel and Tulare Lake Basin about water other than water from the Kings River system, because I think that does affect, to some extent, the scope of phase 1A. So I think what I'll do is maybe I'll turn first to Mr. Keel to maybe summarize the issue about water other than Kings River water. And then I'd like to turn directly, if I may, to Mr. O'Brien and Semi-Tropic to see if you have any responses to it. I mean, I guess my question is, should the hearing notice explicitly exclude any consideration of evidence other than Kings River water? What is the intent of Semi-Tropic on that point in terms of presenting evidence? What can we expect? Because we can narrow these issues. I think it makes sense to do so. But if not, then not. So I did want to talk about that a little bit today. Mr. Keel, may I ask you to speak first on the issue, make sure I understand it, and then I'll turn to Mr. O'Brien, and then I will turn to the rest of you if you have comments on that.
Thank you for the opportunity. I will try to make it brief. These two water right licenses are pertinent to the former Tulare Lake bed. Lake bed was reclaimed starting in about the 1890s. It is a terminal basin, which is the terminus for multiple streams. Cahuilla, Tule River, Poso Creek, Kern River, many of those only reach the lake basin during periods of significant flooding. It's also the terminus for the South Fork Kings River. The history of how these water rights came came to be is complicated, and I won't try to go into that now. But I'll note that the more senior of the two licenses that are associated with the lake bed, its sole source is Kings River water via the South Fork. The more junior of the two licenses have multiple sources to them. The stated source for the junior license is simply Tulare Lake. Now this is kind of an ill-defined water body. There is no more lake. It is really just farmland, water storage cells, and man-made canals. But we know, as a practical matter, water comes in from many different directions from different water sources. So that's kind of the water rights source issue. This proceeding has noticed only on Kings River. Their Semitopic's complaint alleges only forfeiture regarding non-use of available Kings River water. So so if these other sources are coming in, then we'll need to have broader notice and many more parties dealing with non-Kings River sources. Alternatively, clarification to the notice that these other sources are not subject to potential revocation and cease and desist, which is our recommendation, would greatly simplify our efforts. Now, we will still need to discuss what those other sources are, because it does go to demonstrate beneficial diversion and use under these water rights. So I'll pause there. Do you have any other questions about our statements and recommendations?
No, thank you. That was a helpful summary. Thank you, Mr. Keel. And then Mr. O'Brien.
This may be an issue we can greatly simplify, Ms. Lindsay. I will need to confer with my client on this, but I have a feeling that we would be willing to stipulate that our complaint and water right application really only go to Kings River water. That's always been our principal focus. So this may be one we can really kind of make go away.
Good. That would be, I understand you need to confer with your client and maybe work together, but if you are able to do that, I guess what I would want to make that clear before, but we can see what the timing is. If you can work together and then get something into me on that point, whether it is that you're successful in reaching a stipulation or agreement or narrowing these issues, that would be great. Or in the alternative, if not, and then I can decide how to go from there.
We will work on that promptly.
Great, thank you. Is there anyone else who wishes to comment on this issue? Great. I believe now we're in what I have identified as the miscellaneous portion of issues. On notices of intent to appear, I know several of you noted that it may be appropriate to push off that deadline. What I'd like to do is keep the February 15th, 2021 deadline for initial notices of intent to appear, but I'll make clear in my procedural ruling that those are just to identify the parties who wish to participate in phase, any phase of the proceeding. I'm trying to build a service list that's usable. So for parties who wish to participate in any phase of the proceeding, please submit, and you should submit, a notice of intent to appear by February 15th, 2021. Let's keep that date so we can build a service list. I'll circulate that service list shortly after so we all have something to work with that's a little more manageable. But those notices of intent to appear don't need to include your witnesses or the time expectation, just the party contact information for the appropriate representative so we can build a service list. And then I'll set separate deadlines closer to the start of each phase that would require the full notice of intent to appear with a witness list. So you could phrase it as an amended notice of intent to appear. So you have a chance to put in that witness list, or I would require you to put in your witness list, and you'll have a chance to amend those going forward. But I do just want to build a service list up front and make sure we have that. But there will be a second opportunity closer to the start of the hearing Does that make sense? And are there any comments or questions on that issue with the notices of intent to appear? All right. Hearing none. It looks like, I think the last I have on my list of issues to address is this question raised by Mr. Keel on a clarification of the water board staff, separation of functions, and possibly ex parte issues. And I think that's a reasonable request that the AHO issue a more clear statement. There was a statement in the hearing notice stating that the Administrative Hearings Office would be, a hearing officer would be running the proceeding and would be assisted by AHO staff. But I understand there may be concerns about speaking with the division staff at the records room or working with the division on other matters. So I just wanted to make sure I understand from you, Mr. Keel, what the concerns are. But just upfront to say, I think it makes sense for the AHO to explicitly identify who is on the hearing team and who may be involved in discussions on these matters. And we can do that, but I just wanted to make sure that that memo addresses what your concerns are, which is why I want to hear from you. And then I'll invite the other parties if they care to chime in. So Mr. Keel.
You summarized our concerns correctly. It's simply understanding if any Division of Water Rights staff will be advising the AHO to disclose and to separate them from other staff so that we can kind of go about our normal business of communication with the Division of Water Rights.
Okay, and I can tell you right now that the records room staff are not part of the hearing team, and they will be separated from any deliberative discussions I would have with the hearing team. But we'll certainly go through a memo and identify who the hearing team is and make that very clear.
Appreciate that. Thank you.
Are there other comments from any of the other parties on that particular issue? Identifying the hearing team. So that brings us to the end of my list of items to work through. Are there any other issues? The last thing, putting aside, the last thing I'm going to ask once we're done is whether we should set another pre-hearing conference sometime down the road. So let's table that for a moment. But are there any other issues that anyone would like to address or raise today? So I'm hearing from no one at this point. That's excellent. An additional pre-hearing conference, do we need one? Would that be helpful going forward? I realize you don't have a ruling from me yet on when the hearing may be starting. So this may be a bit premature, but I'll get your thoughts on that. I'll start with Mr. O'Brien. Do you think are there outstanding issues that you think we need to address down the road before the start of phase 1A? I mean,
I'm certain there will be, Ms. Kinsey, and I think this has been very helpful for everyone. And I would encourage you to have at least one more and maybe more than that as we move forward.
Do you think we should set it now? Would your preference be that we set it now while we're all on the phone and looking at our calendars, or should we?
I think that would be easiest.
It does sort of make sense, doesn't it? Any objections to that? Otherwise, let's look at suggestions on how far out. Do we want to do 6 weeks, 8 weeks? Maybe 8 weeks out?
Yeah, I was thinking 60 days, something like that.
Let me look at my calendar. So if all of you can please get out your calendars, let's take a look here. That puts us at the end of March. So it appears, well, let's start with the date. How about March 23rd, 2021, in the morning again? Does anyone have a conflict with that date or time? March 23rd, 9 a.m. via Zoom. That works for everyone. Hearing no objection. Great. Let's put that on the calendar. And I'll set in my ruling letter a date, but probably a week in advance for pre-hearing conference statements if there are issues to be raised, whatever it is that you'd like to address at that point. It would be helpful to have some indication of that in advance. Any other comments on that or anything else moving forward before we close this pre-hearing conference? So after today, what I'll plan to do is I'll prepare a ruling on the issues we addressed and send that out. It will also be posted to the AHO webpage for the Kings River Fully Appropriated Streams hearing. I will also send it to the Kings River LIRIS list. And we'll go from here, and then we will reconvene on March 23rd at 9 a.m. And I just want to thank all of you for your participation today. I found this very, very productive. I appreciated your engagement. I appreciated your pre-hearing conference statements. So thank you very much and have a great day.
Thank you.
Thank you.
Thank you.
Thank you.